Welcome, everybody. If you can just take a moment and take a seat. It's so nice to see everybody in person. And welcome to those of you who are online. Between those present and those online, we have about almost 300 people registered, so a very nice turnout. For those of you who don't know me, I'm Lisa Hamilton, and I'm president of the Law Society for this year. Welcome to the 6th annual Law Society of British Columbia Rule of Law Lecture. This is a first for us in terms of this year this is our second Rule of Law Lecture, and we hope in part that it makes up for a little bit of postponing the 2020 and the 2021 lectures. The idea for the lecture series came from the Ethics and Lawyer Independence Committee, as it's known now. And the idea was to look at the rule of law. It's obviously a foundational constitutional principle in Canada, and yet it's understood by people very unevenly, even lawyers. The rule of law as a principle tends to be thrown around in articles and in news stories and speeches, but it doesn't come with much explanation or context. So the idea of instituting a lecture series was the Law Society hoped to bring various viewpoints forward on the rule of law and to actually link the concept to concrete examples in society in order to demonstrate the value and the importance of the rule of law. And today's lecture will focus on war crimes, the rule of law, and the role of the International Criminal Court. And shortly, I will hand over the proceedings to Don Avison, QC, to introduce our very special lecturer. Before doing so, I wish to acknowledge that the Law Society governs lawyers on the treaty and unceded Indigenous territories across the lands now known as British Columbia. And the Law Society also recognizes the Indigenous territories across the lands known as Canada, which is home to a large diversity of First Nations, Métis, and Inuit. Those of us who are gathered in person today are acknowledging, and I hereby acknowledge on behalf of us, the traditional lands of the Coast Salish people, and in particular the Squamish, the Musqueam, and the Tsleil-Waututh people. And I thank them for their hospitality and for their stewardship of these lands. I also invite those of you attending online, nearly 100 of you, from across the province and in Canada, to reflect on and acknowledge the Indigenous peoples on whose land you are attending from today. I also want to acknowledge, particularly since we're talking about law and the rule of law, that Canada is a legally pluralistic country with many legal systems operating on the lands and in relation to the people, including the Crown's civil and common law legal orders and multiple Indigenous legal orders. Recognition of Indigenous laws is essential for reconciliation and for the rule of law. And on that note, I will turn it over to the Law Society's Executive Director and CEO, Don Avison, QC, to introduce our very special guest and lecturer. Thank you.
Well, thanks very much, President Hamilton, and permit me to start in a similar way to Lisa by thanking all of you for joining us here, both in person and online, for this lecture on the rule of law. It's in Vancouver, a warm and sunny afternoon. It's always a bit of a concern about whether or not in those circumstances we'll see a significant turnout, and so this is really, frankly, extraordinary to have so many of you out here today. And it is my honor and my privilege to introduce Judge Kimberly Prost of the International Criminal Court to you today. Judge Prost graduated from the Faculty of Law at the University of Manitoba in 1981. She was a gold medalist. She was with the Winnipeg Regional Office for about 5 years, and I will just pause to reference that Judge Prost had the benefit of the mentorship of David Frere QC, who in my view is one of the great lawyers in Canada, who is no longer with us, but we had an opportunity to have a conversation about Dave Frere recently, and I'm pleased to have this chance to recognize how significant he was, not only for Kim, but for me too. Kim was recruited by the Department of Justice to come to Ottawa in 1987, where she was counsel with Justice Canada's Crimes Against Humanity and War Crimes Unit, and was there for some period of time before she then joined the International Assistance Group within the Department of Justice, becoming the director of that office in 1994. During that period of time, she transformed that office into a much more effective, much more powerful organization than it had ever been before, and was responsible for the negotiation of and the robust implementation of more than 40 of Canada's extradition and mutual legal assistance treaties. Well, with the International Assistance Group, she played a lead role on many prominent and significant cases, some of which will be known to many of you in the audience. Justice Prost was a key member of Canada's delegation on the negotiation of the Rome Statute on the establishment of an international criminal court, assisted with the development of the court's rules of procedure and evidence, and was also a part of the Canadian delegation in the negotiation of the United Nations Convention Against Transnational Organized Crime. She left Justice Canada in the summer of 2000. Actually, she left Canada in the summer of 2000 to join the office of the Commonwealth Secretariat in London, where she quickly became the head of the Criminal Law Section and the Deputy Director of the Legal and Constitutional Affairs Division. After 5 years with the Secretariat, she briefly joined the United Nations Office on Drugs and Crime in Vienna. I say brief because only a short time after arriving in Vienna, she was elected by the United Nations General Assembly as an ad litem judge for the International Criminal Tribunal for the former Yugoslavia, sitting in one case on a trial that lasted 4 years in Popovic et al., and on a number of other significant matters. After completing her time with the court, Judge Prost then moved to a new role, and for 5 years was the United Nations Security Council's ombudsperson on the Al-Qaeda Sanctions Committee. In December of 2017, Judge Prost was appointed as a judge of the International Criminal Court, which is situated in The Hague. Judge Prost joins us this evening to talk to us about war crimes, the rule of law, and the role of the International Criminal Court. And I would ask you to join me in please welcoming Justice Kimberly Prost to the Law Society's Rule of Law Lecture Series. Judge Prost.
Well, thank you very much. Thanks very much to the Law Society, Lisa, Dawn, for giving me the opportunity to be here tonight to share some reflections on my work. And thank you, Dawn, for that kind introduction, especially since we started out as prosecutors together, and you know stuff that you didn't mention. I'm always a little leery when I'm introduced and people go through my CV, because it does tend to indicate that I have had trouble holding down a job, which is definitely the case. It's particularly special to be here in my homeland tonight and to see so many familiar faces amongst the crowd, although I acknowledge that is also somewhat terrifying, so please be kind, and you know who you are. In the limited time we have, I'm going to try and give you a snapshot of the structure of the International Criminal Court and the system that surrounds it, and a sense of the operations, and then we can explore that with further questions, because we'll have a time for questions and answers. It's quite appropriate that this is a part of a lecture series on the rule of law, because the International Criminal Court is one of the institutions that's been established at the international level with the aim of entrenching the rule of law internationally. And that is a goal which can be described perhaps as quite ambitious, perhaps even utopian. Because if you think that there are challenges, as you mentioned, with the interpretation of the rule of law domestically, at the international level, there is simply no consensus as to the content of the rule of law, nor even as to whether it is a beneficial fundamental principle. So in that context, it's quite interesting that, at least at an academic level, the idea of creating an international body responsible to adjudicate on individual criminal responsibility for atrocity crime, which is what the ICC does, has been the subject of discussion since the late 1800s. However, tragically, it took the massive scale of atrocity crimes perpetrated during World War II to provide momentum to act on those ideas. And the most important step forward came when, in the aftermath, the remarkable decision was taken by the Allied forces to opt for trials at Nuremberg and at Tokyo. And if you think about the destruction and the devastation in the world at that time, to make that decision, to take the effort to do that, was a remarkable step forward for the rule of law. And it triggered the idea that there should be a permanent international criminal court to carry on from that moment. And it was, looking back, probably a perfect set of conditions for that idea, because after World War II, there were striking achievements in terms of the architecture internationally to prevent conflict, to protect civilians, and to advance peace and security. You'll be familiar with all of the advancements made. The United Nations was created, which is now essentially a universal body. The International Court of Justice was established, which is the court that deals with issues between states. And the Universal Declaration on Human Rights was also adopted in the wake of, after the aftermath of the war. And interestingly, the groundwork for a permanent court was, in fact, quite advanced in that period. We had the advancement of the Geneva Conventions, which essentially codified and provided us with definitions of war crimes, and the adoption of the Genocide Convention, which similarly applied to that crime. And a draft statute was even in the works in the International Law Commission. But despite all these factors, as is the nature of international law, an area that meets with politics all the time, the establishment of a permanent international criminal court at that time floundered. And it did so because there were significant legal issues about the definition of aggression, which still arise today, but mostly because of the political atmosphere. The Cold War arrived, and in an atmosphere of hostility and distrust, it was simply not possible to agree on an international body which could be given the responsibility to judge individual responsibility for crime, the most sensitive aspect of rule of law. And what followed then was a complete regression. The lessons of Nuremberg and Tokyo were lost, and for almost 40 years, we saw atrocity crime after atrocity crime committed with essentially impunity. For the victims, there was simply no possibility of justice. Haiti, Uganda, Mozambique, Cambodia, Algeria, the list goes on. And it's hard to identify what precisely triggered the change or the response to that, but I like to think it was accumulation, and there came a point when from various aspects of the world community, there was a will to finally say enough in terms of impunity for these grave crimes. And actually, again, as is the nature of international law, it took a very particular combination of circumstances, factual and political, to create a perfect storm of conditions, and a small window opened in the 1990s in which establishment of this court became possible. And fortunately, We were ready to climb through that window because of all the work that had been done in preparation for it. And so diplomatic conference was convened after 2 years, 2 years of very tough negotiations in New York, and then 6 incredible weeks in Rome, which led on the 17th of July, 1998, to the adoption of the Rome Statute, when Philippe Kirsch, a Canadian, gavelled in the accepted compromise package that became the statute for the International Criminal Court. And to our shock, those of us who were present that night, and I still remember it as if it was yesterday, to our shock, it required 60 states to sign on to this statute for the court to come into force. And we were thinking, 10 years, 12 years, 4 years later, in 2002, on Canada Day, we had the International Criminal Court operational. So this history of how this court has arisen essentially creates it as a unique body. So what I want to try and do is highlight for you the unique features of the International Criminal Court. And essentially, it's probably easier for me, and that's what I will do, is to describe to you what the court is not, as opposed to what the court is, because there are so many misconceptions about that, and I hope I can clarify through that outline. The first important point is this is not a court empowered to address all forms of serious and grave crime, which sadly our world faces all the time. Its scope is limited to 4 crimes which are defined in great detail in the statutory framework that governs the work of the court: war crimes, crimes against humanity, genocide, and most recently, the crime of aggression was activated. And in addition to the fact that these crimes are limited to those 4 areas, it is also prospective. Crimes which took place post-2002 are alleged to have taken place post-2002 are the ones which are governed by the International Criminal Court. And related to that is the ICC is not like the International Court of Justice, nor is it like the ad hoc tribunals, which were part of the factors that led to these perfect conditions that allowed for the court to be negotiated. In the early 1990s, in the face of what had gone on in the former Yugoslavia conflict and the genocide in Rwanda, the Security Council took an extraordinary step and had created ad hoc tribunals for those crimes which had primary jurisdiction, so they could do all of the serious cases, and they took control, in essence, of those cases. I had the privilege, as Don mentioned, to serve at the ICTY. But the ICC is very different. The ICC is not a part of the UN system. Cooperation and involvement with the Yugoslav and Rwanda tribunals was obligatory for every member state of the United Nations. But that is not the case for the ICC, which is a treaty negotiation. So each state must determine if they will subject themselves to the jurisdiction of the International Criminal Court. And while to date 123 states have done so, which makes it a truly international court, it is not universal. And that is a source of challenges and leads to criticism of the court, because it has a natural effect on what the court can investigate and prosecute. So the jurisdiction provisions that were negotiated, when it comes to war crimes, crimes against humanity, or genocide, the court only has jurisdiction if the alleged crimes are alleged to have been perpetrated by a national of a state party or on the territory of a state party. And very sadly, there are a number of non-states parties who have horrific conflicts at this time: Yemen, Syria, but the court has no jurisdiction over those situations. And this, of course, has led to the criticism, which I'm sure some of you have heard, and it is an issue, that the court is actually operating selectively. Why Africa? Why not Syria? Why not other particular areas or allegations. And part of the reason for that is because of this jurisdictional limitation. In the case of aggression, the jurisdiction is even more limited. It is only where the allegations relate to alleged acts of aggression by a state party's national. So you can see the relevance of that in certain contexts today. So the third point about the court and its structure, and this is unquestionably the most misunderstood aspect. What was created in Rome was not a super court. It was not a standalone court which carries out enforcement with respect to these crimes. It wasn't even the idea that it would take all of the cases involving the most serious offenders. Instead, what was created at Rome, and this is so important, was a system, the Rome Statute system. And it is designed to bring accountability and an end to impunity for grave crime by operating on the principle of complementarity. The court operates on the principle of complementarity. The Rome Statute recognizes that the right and the responsibility to investigate and prosecute these crimes rests first and foremost with the territorial state where they occurred. And in addition, it calls upon and hopes for additionally in circumstances where the territorial state is unable or unwilling to deal with these situations, that states will use extraterritorial jurisdictions. Other states will contribute. And only where there is no state which is willing and able to carry out the prosecutions and investigations for these situations does the International Criminal Court have jurisdiction. That is a legal limitation on our ability to investigate and prosecute, with the idea being the whole point of this system is to motivate states which had not been taking up their responsibilities in order that you can have a web of activity in response to these crimes. Because we have 3 courtrooms. And you can see, therefore, that it is not possible for the International Criminal Court to be taking all these cases on board. And this is a critical structural point in terms of the rule of law and some of the criticisms of the ICC. It's not designed to impose its version of the rule of law. Rather, it's designed to ensure that the systems that are in place, however they envisage the rule of law, will operate to bring an end to these horrendous crimes. And even if we don't agree with the interpretation of the rule of law amongst us, these crimes are such that every state should be willing and able to prosecute. And it's interesting because this principle, which is fundamental to the operation of the Rome Stat, has been a bit of a double-edged sword in terms of how the success of the ICC is measured. Because it is not, of course it's important that the court is efficient and effective in carrying out its work and has cases that it is proceeding with, but it's also essential that there be efficient and effective investigation and prosecution nationally. And that has been an aspect of the system which has been not the subject of sufficient focus from the original coming into force of the Rome Statute. But I'm happy to say today we are seeing a much more robust efforts to help states to be able to do their own prosecutions, with special chambers operating in the Central African Republic, in Uganda, and with a number of efforts being made in that regard. So we are, I think, making progress towards real complementarity in action. And finally, this is a question I get a lot, because these aren't crimes where someone goes down to the local station, obviously, and reports on them. So often the question is, well, just how do you decide? How do you decide in this world of conflict and challenge which cases are going to proceed before the court? And of course, the ICC system has a prosecutor, which is one of the organs of the court itself, and the prosecutor operates independently, and ultimately it is the discretion of her or him as to which situations will get prioritized. But as a protection during the negotiations, there were very strict rules put in place as to how these situations could be brought before the court. And there are three basic methods. First, states parties to the Rome Statute can refer a situation to the court. And it's a very interesting story because a lot of time and energy was spent during the negotiations trying to put protections in place to make sure the court didn't turn into a political battleground with one state referring their neighbor to the court because they were having a fight or a dispute over something completely different or irrelevant. And that was what was being anticipated. What was never anticipated, I've never found a single person who was in those negotiations who even thought of this, but the first 4 situations referred to the court were self-referred. States referred situations in their states which they felt they were unable to deal with, starting with the Lord's Resistance Army, the terrible, tragic attacks in northern Uganda, which the Ugandan government referred to the court. And it was followed on by the Central African Republic, the Democratic Republic of Congo. And so back to that whole issue about, is the court persecuting Africa? Well, part of the other aspect of that is that these states asked the court to intervene. And at first we were all a bit surprised at all of this, but when you looked at the statutory provisions, it was perfectly acceptable. So that has become a major component of how situations appear at the court. And in fact, we never had a state referring another state until 2018, when Canada and a group of states referred Venezuela. That was the first time we had a pure state referral as we had feared it or contemplated it. The second method, and this one we thought, there's no chance on earth this is ever going to happen. Again, we were not predicting very well. The Security Council can refer situations to the court. But given that 3 of the 5, and I don't think it'll take you a long time to figure out which 3 of the 5 permanent members of the Security Council are not members of the Rome Statute, we thought it would never, a referral would never get through. But the situation in Darfur in 2005 was so outrageous that we managed to have a referral of that situation to the Security Council, which means even though Sudan is not a party to the Rome Statute, the court has jurisdiction. And the first case arising from that horrible scenario is before our court right now, running, the trial is running. And it was followed on in 2011 by Libya, which has also been referred. And then finally, the prosecutor, himself, can also, of their own initiative, carry out proprio motu investigations. But there was a lot of fear of that rogue prosecutor, the guy's or girl who's going out there a bit. We've not had that, let me make that clear. All of the prosecutors have been very dedicated and doing a very difficult job. But as a result, there are restrictions on that proprio motu power. So when the prosecutor wants to investigate, that has to be approved by a pretrial chamber of 3 judges, as has happened in the case of Burundi, the Philippines, and very recently Afghanistan. So those are the ways in which the court receives the cases that it investigates. And I imagine you're thinking, my goodness, with all those restrictions and limitations, it must be pretty quiet at the International Criminal Court, but I can tell you very sadly, that is not the case, because there are 17 situations under investigation, and right now we're running the most trials we've ever run simultaneously, 5 trials arising from 4 different situations, and there is an additional case which is in the pretrial, with the pretrial division, which of course has the discretion to confirm or not the charges. So it is a very busy time for the ICC. In terms of so that's your basic structure. I'll just touch briefly before we open up on how investigations and trials are managed. I won't go into the details of it, but those of you, and I know there's some investigators in the room, those of you can imagine the complexity of these investigations. I mean, each situation, you have to look at the context, the culture. You have to find people who speak languages, often local languages, for whom there are no interpreters. So every investigation is very difficult. My former boss, because I served as chef de cabinet to the president of the court before I was elected as a judge, and she used to, when asked about how hard her job was as president, she'd say, "My job is difficult, the prosecutor's job is impossible." And there's a lot of truth to that. So there is the complexity, but let me just highlight two features, one relating to investigations and then a little bit about the judges and what it's like to have to judge in these cases. The interesting thing that's so different from domestic investigations is that the ICC has no police force. And because of the principles of sovereignty, we certainly can't go marching into a country and try and gather evidence or arrest people. That would not go down very well. So we are entirely dependent on cooperation. And that is, there is an elaborate system. I was part of the negotiating teams on that part, and it's a very good part. Well written, perhaps not well implemented, but there we are. And that is the way and means by which all of the evidence is gathered and all of the arrests are effected. And we've had 31 cases advanced to date. So the system is working. It's slow, it's difficult, it's not nearly as effective as we would like, but it does function. But at the same time, one of the Achilles' heels, it's openly criticized and certainly understandably, we have outstanding 15 arrest warrants that I know of, because the prosecutor could have warrants under seal. And that's a massive number of individuals. Sometimes we can't find them, like Joseph Kony, who's the LRA has been missing for years, but otherwise it's questions of willingness and ability of states to carry out their obligations. And just briefly, what's it like to be a judge at the International Criminal Court? Well, there's many things. I can do a whole speech on that, but I won't do that. It's a nice night in August. But the most fascinating thing is that there's 18 of us, by the way, divided into 3 divisions, although there's some crossover between pretrial and trial. And we're, at the moment, complete parity. 9 men, 9 women. And it is geographically very distinct, 5 geographic groups represented on the bench. And every 3 years, 6 judges go and 6 judges come. You can imagine those judges in the room, how that makes it a bit difficult to build a consistent judicial collegiality atmosphere and practice. And even more challenging, one of the great accomplishments of the Rome Statute is that it is a purely hybrid system. It's not common law, it's not civil law, it's got those 2 systems mixed in, and it's got other traditions built in there as well from the negotiating process, which is fantastic, except so much time and effort went into that at Rome, we completely ran out of time. So all we have governing the procedures in the courtroom are a couple of basic principles. I mean, to give you a sense, the statute doesn't even provide who goes first calling evidence, because we couldn't agree on that. And we don't even have a name for the document that has the charges. We couldn't call it an indictment, so it's called the DCC, Document Containing Charges. You know, you find solutions. So everything has been left to the judges. And each case at the beginning, every single chamber was reinventing the world, setting the procedures, how this is going to go, whether we're going to have a real common law bent with, admissibility of evidence, or we're going to let everything chaos. As you can imagine, that's not good for consistency and predictability and efficiency. But I'm telling you, it is not easy, especially when those 6 arrive and they all have new ideas that they think are, haven't been dealt with before. Anyway, I can report, and I wasn't able to report until like a year ago, that we're doing a marvelous job at this point, the judges agreeing on a consistent practice which is being captured in a chamber's practice manual. And this year, we adopted a framework conduct of proceedings decision, it was a miracle, and one evidence system, complete miracle. So there you have it. That is what makes the job so fascinating and interesting, but also challenging. But I do believe in that respect we are progressing. Listen, let me stop there, and so we can do some more fleshing out in terms of the statute and the work. But I just wanted a few closing thoughts. It's not an overstatement to say it's a miracle that we have the International Criminal Court. It's tied, as I said, to the statute, the tribunals having been created and that prompting action, to Trinidad and Tobago. Trinidad and Tobago having resurrected the original draft from the ILC because they wanted an international court for drug crimes. And of course, because Glasnost arrived and saved us politically. So it is a miracle, those factors that came together. And I'm firmly of the view we would never establish this court today. It would be impossible in the current political context. At the same time, the ICC and the Rome Statute system are far from perfect. There are many complications, there are many issues. We've had a review which has identified structural problems, legal problems, and the court has certainly been the subject of criticism over delay, over inefficiencies. Some of it is unwarranted because it arises from structure, but much of it is justified, and we have to find ways to improve, and we must address the missteps of the past and move over them. But despite all these weaknesses, I'm a firm believer that the world is a better place with the International Criminal Court than without it, and with this Rome Statute system. And we have advanced, because today accountability and justice for atrocity crimes is not only a possibility for victims, it's an expectation. And the court and the Rome Statute system have contributed to that advancement in the international community. So going forward, it is for the next generation to safeguard the progress that we have made and to strive to improve to the point where those expectations don't just exist, but they can be met. Thank you so much for coming out on this night and for listening to me.
So, I think this. The usual practice with the rule of law lectures is we have a bit of an opportunity for a few questions from me to you, and then we'll open up for some questions from the floor. But I want to start just by thanking you for that very comprehensive presentation in relation to how the court was formed and how it operates. There are a number of questions that I have for you. You want to start with the easy one? I think the elephant in the room, and there may be, I'm sure there are, significant limitations on what you can say about this, but it's very much on the mind, I'm sure, of everybody about some of the events that are taking place elsewhere in the world. And so I am curious to know whether you're able to offer some insight in relation to what role the court might have in relation to any events currently unfolding in Ukraine.
Well, thanks, Don. And of course, that is a topic that is very much on the minds, I know, of Canadians in particular. As a judge of the International Criminal Court, obviously, I know you all understand that I can't comment on anything related to ongoing investigations or prosecutions. But what I can do is recount what is publicly known and acknowledged by the prosecutor of the court, and that should clarify at least the situation with the court vis-a-vis the conflict in Ukraine. Neither Russia nor Ukraine are parties to the Rome Statute. However, Ukraine, several years ago, had attuned to the jurisdiction of the court. You can file a declaration accepting the jurisdiction of the court without having become a state party. It's provided for in the statute. And they, like a couple of other states, had done that. So as a result, with respect to war crimes, crimes against humanity, and genocide, the International Criminal Court does have jurisdiction over the conflict in Ukraine, importantly with respect to any alleged crimes by either side to that conflict. Then the question became, of course, whether the prosecutor would identify this as a potential site for investigation. And he made a very public announcement that he was indeed planning very early on to open an investigation into the situation in the face of very public allegations of crimes being committed. And he was going to do that proprio motu, as I described. But he pointed out in the press release that, of course, that would take some time because it will need approval. And will not take as much time if there were referrals. And 43 states then referred the situation in Ukraine to the court, with the result that there is an open investigation in Ukraine, and the prosecutor has spoken openly about the fact that he has investigators present and that there's work being carried out in coordination also with Ukraine itself, with other states. Not coordination in terms of the crimes being investigated, but there has to be an understanding as to cooperation with the court, separated and apart from whatever may be carried out by either Ukraine or Russia. So that's the situation. That's the extent of what I can say, and it's actually all I really know, because the prosecutor said so.
So I'm quite interested to know a little bit more about how the court deals with witnesses and with victims of war crimes and crimes against humanity. The Hague is a long way away from the locations where many of the allegations originate from. So what is the process to ensure that the voice of those who are on the wrong side of some of these activities actually finds expression in the court?
It's an issue that, of course, plagues all international courts and tribunals who do not sit in the site of where the crimes were committed, and it's a function of the nature of the business. In a way, the tribunals had the same issue. But there's been some very unique aspects the Rome Statute provides, not only for a reparation process, which then involves victims very carefully upon conviction, but we also have a unique victim participation system. So it's not the French system where they actually have parties that are victims, but it is a compromise whereby we have counsel in the trials representing victims, separate and apart from the prosecutor and the defense. Now they have a limited role, and the bench has to control that. But in my trial, for example, I'm on a trial related to Mali. We have a very active representative of victims. So that's one way. And then the other thing we have to do, which we work on very much, is controlling our outreach and ensuring we do as much outreach as possible, broadcasting the trials, opening the trials very publicly with a live streaming and things of that nature. But that's an enormous challenge, especially since many of our situations are still in very difficult scenarios. But we do have a very conscious understanding of the need for all of that.
And you talked about the role of the prosecutor and the structure of the prosecutorial function. But I think people would be interested in hearing a little bit more about how people come to be involved with the prosecution and the defense function within the court.
Yeah, the prosecutors, are all staff members, so that's a fairly straightforward process. You can apply their advertised positions. The prosecutor, it's currently himself, is elected by the state's parties, and that happened recently. We had the election of the third prosecutor of the court, and the deputy prosecutors are similarly elected, and that also just happened. But on the defense side, it's very different, because the idea of having a permanent defense office came very late in negotiations, and so it didn't succeed into the compromise. So instead, what we do have is there is a list of counsel. You can apply to be a counsel before the International Criminal Court, and those who come to the court are given the opportunity to choose counsel from that list if they are relying on court funding for their defense. If they have funds sufficient to defend, it's like any system, they will pick whom they wish to defend them. But we have the criteria and that approach. But it's a very challenging, right now there's a big review going on of defense, because you can imagine it's a very challenging issue as to how individuals being brought from other jurisdictions can possibly make a choice off of these lists in terms of counsel they wish to engage. Of course, we have very experienced counsel who are also ICTY and ICTR, but still, it's a very challenging process. But we do have some excellent counsel that appear in front of the court.
I thought it was quite interesting when you talked about some of the issues associated with cases that have arisen from Africa, and that in a number of those situations there have been self-referrals by states. But is there a concern that over time, if there continues to be a disproportionate focus on African states and other states that are perhaps less stable than others, that will have some impact on the credibility of the court?
Well, I think the prosecutor is always conscious in having to make those choices on prioritization. As I said, there were many factors which led to the situation with the cases, the primary source of the cases being Africa. And in addition to the things I mentioned about jurisdiction and also self-referrals, Africa is the continent with the most states parties who are members. So it's not shocking that there would be a number of cases from there, and there are horrific conflicts. And I always say, but what about the victims? It says basically that the ICC is concerned about African victims. So I think, for me, it is not an issue that should be focused on as a question of Africa or others or persecution or not, but it should be an issue for the prosecutor as to selecting and being sure that he's being as open as he can be to other situations. And now, of course, the scenario is quite different because we do have other investigations in Afghanistan and Burundi, in Myanmar, well, Burundi is in Africa, Afghanistan, in Myanmar through Bangladesh, complicated situation, and now the opening of the investigation in Ukraine, and there were warrants issued recently in the situation in Georgia. So I think it's perhaps part of the growing up of the International Criminal Court.
Well, perhaps I'll ask one more, and then we'll see if we have some questions from the floor. And I think I have this right. My recollection is that at some point in the not-too-distant past, in engagement with the United States, that members of the court, the prosecutors, and their families were subject to restrictions on your capacity to enter the United States. Is that true, and what do you make of that?
Yes, there was a sanction regime introduced under the Trump administration, which effectively placed the International Criminal Court on a list whereby those working at the court, with the court, could be subject to sanctions. And our prosecutor at the time, Fatou Bensouda, and the head of the cooperation unit were subjected to sanctions, which is a huge, you can't even begin to, I worked on sanctions when I was the ombudsperson, so it's extraordinarily difficult. It was difficult for the court, very difficult for Fatou and Pekiso. And I mean, I won't talk about it in depth. I think it's self-explanatory perhaps as to why the action was taken, but the positive note is that we managed to survive that. We were strongly supported by our states parties in terms of pushback on those sanctions, and now the Biden administration has very publicly and very vocally, the sanction regime has no longer functioning, and they have been carrying out a real program to reach out to the court and rebuild the relationship, a good relationship as we had previously with the United States. Not a state party, but it has been very constructive in engaging and assisting the court in its work. So I'm glad we're through that era, but I can assure you it was a very difficult time for the International Criminal Court.
All right, well, let's see if we have some questions from the floor. We'll call this microphone number 1 and microphone number 2. We'll alternate between the two, and we'll start with microphone number 2. I just ask that you say who you are and then state your question.
Good, thank you. My name is John Boone. I'm a lawyer in Vancouver. I'm still a little bit unclear as to how the court can assert jurisdiction over a non-signatory party. Because you suggested with Darfur and with Ukraine that the court does have some jurisdiction, but how does that exactly work? And you can trigger an investigation, but you can't actually get a state party from a non-signatory state into the dock. How does that exactly work?
No, it's a very good question, and it is certainly not a straightforward point. Let me separate those two situations. So in the situation with Darfur and Libya, there's no issue, because even though they're not states parties, they are members of the United Nations, and the referral by the Security Council included a direction from the Security Council that they must cooperate. They must cooperate in evidence gathering and in the surrender. Now, whether that was effectively implemented is a different issue, because we were just starting the first trial in Darfur this year. But there's no legal question there because of the powers of the Security Council under the Charter. When it comes to, Ukraine just happens to be a declaration, but when it comes to any situation where it is based on the fact that the crimes are being committed in the territory of a state party, which is the situation there, that's the most controversial point, and that is one of the issues for the United States, is that there is the argument that it's an extraterritorial stretch of jurisdiction because the other party to the conflict is not a state party and it's not their territory. But that was the negotiated agreement, and there's extensive public international lawyers writing on the topic, but it is simply the jurisdiction has been accepted on the basis of the way in which the treaty is framed. And it's not unique in terms of treaties having an effect on non-states parties. But you raise the practical question, which is of course the problem. You can do an investigation, you can identify suspects, you can issue warrants, but if you're dealing with warrants against those who are nationals of a non-state party, you are going to have practical challenges in most cases in trying to get them. And that's what we struggle with, of course, in those kinds of situations.
Senator McFadden.
Thank you very much, and thank you to the Law Society for hosting this, and to the Honourable Judge Kimberly Prost for being with us this evening. My question is picking up on a reference that you made to victims, alleged victims, complainants, something that there's been some writing on and expressed concerns over the years is a differential between how witnesses are supported and treated by the court versus those who are facing the charges. And for example, one of the concerns expressed that I'm aware of was that the standard of accommodation and availability for supports, per diems, etc., differed for witnesses as compared to those charged. I'm wondering whether that's still the case, and if you're in a position to speak to there being parity for the parties, essentially, and the witnesses in the proceedings.
Well, certainly, in our context, it's somewhat distinct in so far as there's a great difference in terms of accommodation, for example, or those issues, because with the exception of one administration of justice trial, which is ongoing, where the accused is on bail, all of our accused are accommodated in the prison at Scheveningen. I can't pronounce it. I live there. Scheveningen, the Dutch prison. But I do take your point, which is how the treatments are, the rights and the protections. Fortunately, there is a very strong provision in the Rome Statute about the obligation of the chamber not only to safeguard the rights of the accused, which is of course paramount, but to safeguard the rights and well-being of our witnesses and victims. And we have an entire section that does marvelous work with all of our witnesses who are brought in. As you can imagine, it's extremely intimidating to come from these jurisdictions to The Hague and walk into one of these courtrooms. They do a wonderful job, they do an assessment. So I think our statute and our system has one of the best protections for ensuring that balance in terms of treating not only fairness for the accused, but also for our victims and witnesses.
Microphone number 2.
Thank you very much. Madam Justice, I just wanted to thank you for having the privilege of attending your talk today. My background is not law, so I do apologize for any misunderstanding or shortcoming in my understanding. My problem, ma'am, was regarding the rule of law and the role of International Criminal Court. And it goes back to 3 stages of where the biggest, baddest elephant in the room, namely the United States, is concerned. They did attend the Rome Convention, and they did try to affect some of the ongoing sort of rules and the convention itself, and they did for the most part. But they did not ratify it. Of the 123 countries that did ratify it, the US is not one. They did not stop at that passive part. Starting with George W. Bush, they have, and until Biden, and you mentioned that Biden has tried to reach out to the court, they have tried, the US has tried to have bi-directional sort of a bilateral sort of conventions regarding extradition and criminal sort of a mini bilateral criminal court between US and each other country. Therefore, actually make the ICC sort of unnecessary. So before the rule of law can be implemented, everybody has to be equal before the law. And when the biggest actor You mentioned Burundi, you mentioned Darfur, Afghanistan, and I think Uganda, if I'm not mistaken. The negative effects of those countries and the actors in those countries don't go beyond their borders, whereas the negative effects of the US goes all over the world, including actually Canada, throughout our history. So how can you I apologize for saying this, but how can you paint such a rosy picture of an organization that actually, when it comes down to it, is not accepted? There is no equality before the law as far as the ICC is concerned, or as far as other people's view of the ICC is concerned, and also the ICC itself, the jurisdiction, is not actually large enough to reach out to some of the baddest actors to bring them before justice. Thank you.
Well, and certainly I understand the points that you're making, and they're not in any way a misunderstanding of the situation. But as I indicated, the Rome Statute is certainly not perfect, and you can be assured that everyone who works at the court is of the view that until we have universal adherence to the Rome Statute, we can't achieve what we're trying to achieve, which is the application of throughout our international community. That's clear. And it is a natural situation that we will have these variances. There are countries who are simply not a party, and therefore we have no jurisdiction, and not just the United States, but others as well. It's not, as I said, not a perfect system, but I am in the camp which says we have to take this step by step. And the advancement and the creation of this court was a huge step forward. There's much more to be done, and we need to build this system and extend it. But in the meantime, I'm not of the view that you throw away that, or you don't pursue that, or you don't support that and advocate for that system because there are these issues of application. And as I said, I was at the Rome negotiations. The United States was hugely constructive in the contributions they made to the statute, and then there were issues and reasons why they chose sovereign right not to join. And now we do have a constructive engagement with them. So all of that is progress. So my view is we take this step by step because that's the nature of international law, and we are making progress.
Thank you very much.
Microphone 1.
Thanks. Sorry. My name is Alexandra Stafford. I'm a PhD student in international relations at the University of Oxford, but my research is focused on international criminal law and institutions, in particular the role that, for lack of a better term, internal diversity plays within international legal institutions. For example, as you alluded to, different understandings of criminal law, different understandings of judicial roles and procedures, and how these contribute to unique innovations, hybrid procedures, etc. You alluded to this a little in your discussion of the kind of victim representatives and rules of procedure and evidence. And my main question is, I suppose, how do you manage and adjudicate these kinds of differences within these courts, within the ICC or the ICTY? What factors would you regard as being the most important for building and maintaining collegiality and coherence, especially with the high turnover, especially with kind of different versions of international legal expertise that you find in these institutions? Thanks.
Well, thanks. That's a very interesting question. It's a very interesting area you're looking at, and it is one of the greatest challenges of working as a judge in these tribunals, and not just a judge, but in all contexts. But my personal knowledge is in that perspective, and at the same time, it is one of the most fascinating parts of the job. And I think what is one of the most important features, I would say, if you're going to do this and try and navigate those differences, is you have to come to the court without carrying your baggage of your legal system and your legal tradition and your culture. You have to come knowing things from that and being willing to share that with your colleagues, but you have to be open to other legal systems, other traditions, other perspectives, and you have to be able to listen, which judges are supposed to be very good at, but it's not always the case, and be prepared to compromise. And I always tell this story. When I was at ICTY, I sat with a fabulous bench, judge from South Korea, a judge from Malta, a reserve judge from Norway. And we had the greatest discussions, but it was particularly hilarious between Judge Kwon from South Korea and myself, who's a dear friend. And we loved to argue. We argued all the time. We drove the others crazy, but we were always listening in those arguments. And the interesting thing was, by about halfway through, it was clear that Judge Kwon, who comes from primarily a civil law tradition, was the biggest fan of the common law, and I couldn't stand the common law precepts and was always advocating for the other side. So that to me is the spirit in which we can navigate through all of these situations. And I'm happy to say that we have a lot of that now at the ICC.
Microphone 2.
Thank you, God, for put me here to be the voice. I don't have a voice. My name is Ragad. I am not law school or have anything with law to do, but I am from East Africa. I just want to ask you, do you have aware of this Tigray people? They first is the war is victim. Now they don't have food to eat. While we are here, we are talking, 100 people is dying from hunger because the government not allowed them to pass the food to them. We have, you mentioned Darfur, Rwanda. We regret because we didn't reach on the time. Now also we are late to these people. I'm just begging you to do something. Help this food. Help these people, these children, this society. Is we going to lose them, then regret, then it's going to be too late. Thank you.
Well, thank you very much for that, and believe me, I understand precisely what you're saying here, and there are days I sit in the courtroom and I hear an individual tale of what's happened, and I know that it's just one story amongst a sea, and I feel the sense of helplessness, I suppose. But I like to think, as I said, the ICC is only one institution dealing with one small part of all of the conflicts, of all of the situations in the world, the corruption, the poverty. And all we can do, I think, is work on each of those. But I take your point, and I thank you very much for reminding me that it's all in a larger context that we also have to always have in mind. Thank you.
Microphone 1.
Good afternoon. My name is Padma Yogan. So regards to the Sri Lanka, I came from a Tamil community. In Sri Lanka, the last more than a decade, the people, grassroots level to the academics level, they're all talking about this ICG, International Criminal Court. So, but the community is really wanted to get these things through the International Criminal Court, because in United Nations, the PTP was failed. So now they are looking for the other option, how you can prosecute the Sri Lankan war criminals, crime against humanity, and who conducted genocide. This is a systematic genocide for more than almost like 100 years. So the question is, this situation is very complex and complicated, and our Tamil community situation is really extremely kind of a situation because we are stateless. There's no protection for Tamil community. So there are 2,000 days in back home in our country. The parents have been doing protests around almost 2,000 days. They are looking for their missing their sons and the daughters and the husband and wives, and the whole thing's going on. So still the international community is still not giving any attention. So how the Canada can help to sponsor or refer Sri Lanka to the International Criminal Court, or along with the other supporting countries aligned with Canada to get these matters to resolve through the International Criminal Court. So this is, the grassroots community activists to They're all talking about it. I don't know how this is going to happen, how we are going to do. So I am taking your advice how we could get it through these ones. Thank you.
Well, thank you very much. And again, as with the last speaker, it is a reminder that there are many situations that exist in the world, and we proceed individually. Unfortunately, because of my role at the court, even though Sri Lanka is not a party to the Rome Statute, I'm not able to comment on a specific situation like that, because perhaps one day Sri Lanka will be a party to the Rome Statute, and then there would be issues arising from that. So I understand your question, and I certainly sympathize with your frustration at the situation, but I think that's the extent of what I can say on the point.
Microphone 2.
Great, thank you. Thank you, Your Honor. My name's Manjot Hallen. I'm a lawyer here in Vancouver, and I also happen to be the honorary consul for Croatia. And so I want to speak to you a little bit about the former Yugoslavia, and the situation that I see there is that the states, Croatia, Serbia, Slovenia, they've had referrals to the international tribunals. They've had a certain sense of justice, and a lot of those countries, there's a sense of healing and a sense of moving on. They're progressing economically, they're joining the EU, they don't want to look backwards, they want to look forward. However, on a population level, on the local level, you still have a lot of pain and hurt, and people whose family members have been killed, property taken from them. And I hear these stories regularly, and the question then becomes, is there a mechanism, or has there been any thought put to a mechanism where you can have a local government or a provincial government or a state government refer a matter? Because in these situations, you very much, in that local situation, there are a group of people that know who the atrocities were committed by, and frankly, the state would even confirm that, but it's just not been referred to the ICC because the state is moving on, for lack of a better word.
Yeah, and you know, I agree with you entirely. I think, I mean, there's huge impact of the work that was done by the former Yugoslavia Tribunal, but it's limited, and you still have lots of healing that needs to be done in every community that ever suffers conflict that goes on for many years. But in answer to your precise question, the state referral has to be by the state government. However, people refer situations all the time to the prosecutor because the prosecutor has propria motu powers. So there's nothing precluding any government, any individuals, NGOs do this all the time. So it is accessible to those kinds of situations, but the difficulty for the situation with the former Yugoslavia is it would be out of time, because it's pre-2002. But it's an interesting question, but just to emphasize that the prosecutor does receive direct communications from all sorts of sources.
Great, thank you.
Mr. McPherson.
Thank you, and thank you, Judge Prost. It was a very interesting discussion. My name is Christopher McPherson. I'm Vice President of the Law Society, and I'm a senior prosecutor in the Lower Mainland. I'll just start by I think one of the most important legal issues, if not the most important legal issue facing Canada, is truth and reconciliation with our Indigenous people. And there is a growing realization that the sort of colonial laws, if you will, that have been imposed in this country does not necessarily serve Indigenous persons the way we would want them to, want our laws to do, and a recognition that there is a whole other body of law. So my question for you is, does the International Criminal Court take steps to try to recognize the Indigenous laws of the various places? I appreciate the states are doing the referrals, but I think you only need to look around the world to realize a lot of the atrocities are directed specifically at Indigenous people who may or may not be served by whether it's a colonial or the state government. So I just am interested in what thoughts you may have on that issue.
Well, thanks. I certainly, I understand the context of the question because I know, I'm a Canadian still and I follow and I know these are very important issues in the country. It goes back though, with the ICC, it goes back to what I said initially, which is that the court has a very specific mandate. And the law we apply, the law that's relevant to us, is the law of the Rome Statute, and that is a hybrid system, which did have some contributions, of course, from various systems, but we simply don't face the issue in terms of we must apply the law of the statutes and the rules, and so we don't face those issues. We do have some interesting issues sometimes about actions that were taken by during an occupation, for example, and whether that constitutes proper tribunals or things of those nature. But the kind of issues that you're highlighting simply don't arise because of the nature of the court and the fact that it's founded on a statute and it operates in that international context.
I think we've got time for questions from those that are currently at the microphone, so I'll go back to microphone number 2.
Hello, Victoria Shin, student. My question is, would it not increase the effectiveness of the ICC in its practice if the court itself adopted a sort of a nomadic methodology of traveling to and setting up their court in the location where the alleged crimes were committed? I would assume that it would decrease the chances of any evidence getting lost in transportation, increase the possibility of various witnesses, to attend the trial in person. And ultimately, I guess the golden question is there a specific reason why the ICC has to be stationary in The Hague or at The Hague?
Well, thank you very much, and that is a very good question. And in fact, I'm going to tell the prosecutor of the court that you asked that question because he's very keen about having sittings of the court in the various situation countries. He's made that very clear in a number of discussions. There is provision for the court to sit outside of The Hague. That was built into the Rome Statute for exactly the important reasons which you have highlighted. But it is extraordinarily challenging. There have been chambers which have done site visits. I did one when I was at ICTY, and the Ongwen trial, for example, did one in northern Uganda. But the problem is that in the vast majority of our situations that are under investigation, it's still a situation of conflict in most of these countries, and the security situation is extraordinary. And it's not just about the risks that presents to the bench, to the judges, to all of the staff we would have to take for that. It's the risks to those who would have to protect us and the resources that would have to go into that. And it's also, we, like everywhere else, the running of the court is we have a huge battle every year. My German colleague likes to note that the budget of the ICC is equivalent to the budget of the Berlin Fire Department. So we face enormous resource challenges, and moving this court, if you ever come to The Hague and come to the court, you'll see the transcriptions. We have translation, interpretation, direct interpretation, court reporter, security. It's a massive operation. So I like to think we are going to be able to do some sittings in situation countries. Everyone agrees with the principle you're stating. It's just the practical realities so far that we've faced.
Thank you.
Thank you.
Microphone 1.
Thank you. My name is Deanne Gaffar. I'm a judge of the Provincial Court of British Columbia here. My question relates to a project that I'm involved in where we are examining the processes of the ICC, seeing how they can be assisted with regards to complementarity, as well as my particular favorite, victims and witnesses, particularly children and women. One of the things that we've been doing is studying the Ongwen decision, mainly because of its breadth and also because the trial completed, sentencing is done. One of the lines that I found extremely interesting, and I'm hoping to get some insight on, is the comment in the sentencing where the court said that the victims essentially owned that process. And I'm wondering if you are in a position, you might not be, to assist us in understanding what the court might have meant.
I would so love to answer your question.
Darn! I promised my two young lawyers that I would try.
I do have things I could say, but the problem is you have to wait about
For the appeal. I know.
For the appeal.
I know.
That's the reason. But it is unquestionably an extremely interesting decision for so many reasons. The presiding judge was my dear colleague and friend, Judge Schmidt. So call me. Call me when that appeal comes down.
Don't worry, we're going to. Thank you.
And last question.
Hi, Diane Terrell from Victoria. Thank you very much for the interesting presentation. I've recently returned from the Democratic Republic of Congo, where I served with the United Nations Peacekeeping Mission as a judicial affairs officer for a number of years. And my question for you is about the cooperation provisions of the Rome Statute. I was in the Congo at a period when al-Bashir was still in power in Sudan, and as you know, he no longer is, and he was taking the occasion of criticism of the International Criminal Court by heads of state in Africa to swan around Africa from state to state and be welcomed by heads of state, despite their countries being members of the Rome Statute, seemingly with impunity. And I wonder, do you think that the cooperation provisions are sufficient or efficient, or are they hindering the work of the ICC at this point?
Well, the last question is on my area of expertise, isn't it? First of all, may I say that the work done, the work that you've just completed is just the work, extraordinary work that is done by the United Nations, and individuals like you. It never gets sufficient recognition and attention, and it's fantastic work. So I really appreciate that you were there and did that role. There is the cooperation regime has many challenges and has been the subject of criticism. With hindsight, I think those of us who worked on the drafting of it would certainly have done things different. But one of the things, and Philippe Kirsch just spoke recently, the chair of the committee for the adoption of the statute, about this. One of the things is that we envisaged, and those of us working on the cooperation regime, we envisaged that the states parties to the Rome Statute would force each other to acknowledge their cooperation obligations. And in fact, the court has consistently, when Bashir made those visits in breach of the statute, the court consistently, all of the chambers, the pretrial chambers, called the states on it. There were decisions, non-cooperation decisions. So the court, I believe, has been doing its role. The problem is, and Kirsch said this openly and others have spoken to it, states parties have to take up their obligations. And the Security Council, and I don't mind bashing the Security Council, I worked with them for 5 years, and they have referred situations to, the two situations, Libya and Darfur, to the court. We have received minimal cooperation in both. The prosecutor goes there every 6 months and complains, and they do nothing to enforce their own referral. I think it's not a credibility problem for the court. I think it's a credibility problem for the Security Council. And in the case of those who are states parties, we have been calling upon states to take some action. And I'm hoping, it was a subject matter in the recent review, I'm hoping that finally the states are going to start taking some action themselves. But that's the only way we can make progress. But you have identified it is a weakness, there's no question, and if I could only go back in time, I tell you I'd put some different things in there. But thank you very much for the question.
Well, thanks very much for all of the questions, and I want to end with where I began, in thanking all of you for taking the time on a warm summer evening to join us here at UBC Robson Square for this session on the rule of law. But I particularly want to thank Justice Prost for taking the time to join us here in Vancouver for this lecture. I know the time back in the country doesn't happen really all that often, and it's never for long enough. So Judge Prost has been able to be back in the country for a couple of weeks. It was in the fall where I said to her, I know you're coming this summer. I know you're going to be in Winnipeg, and I'm pretty sure you're going to be in Kelowna. So could you find some time to come to Vancouver and talk about what's happening with the International Criminal Court? So I deeply appreciate the fact that you took that precious time to spend some time with us here this evening, and I'd ask all of you to join me in thanking Judge Prost for doing so. So thanks again. Judge Prost might have time for a couple of questions down here at the front, and we've only got a little bit of time, but thanks again, all of you, for attending.